Hello friends, this is the first YouTube video episode of our channel Nyay Pathshala. In this channel, we will be discussing various legal topics and its concept from the practical point of view of a lawyer. How to use the legal principle in a criminal trial or on a day-to-day proceedings before any courts. Those are the topics we will be covering in this channel. Today, I have chosen a topic, FIR and its significance during a criminal trial. The importance of FIR in a criminal trial is that it is the first step for initiation of a criminal investigation in motion. Of course, there is another way of also initiating a criminal action or criminal investigation is in motion by filing a criminal complaint before the concerned magisterial court. Under the Code of Criminal Procedure, under section 154, it discusses the concept of FIR. FIR is not as such defined under the Code of Criminal Procedure, but under section 154, if any information is received in regard to commission of a cognizable offence, either it may be in oral or in writing, the police officer will register a case and will start the investigation of the case. Suppose the police officer refuses to register an FIR. So what is the option left to the informant? The informant can file a complaint before the concerned superintendent of police of the district or the deputy commissioner of police or the commissioner in case of some of the cities in India. FIR, once it is filed by the informant, the copy of the FIR has to be given free of cost to the informant. At another stage during a criminal trial, before the criminal trial is initiated, there is a provision under section 207 of the CRPC to furnish a copy of the FIR along with other documents or the statement which the prosecution wants to rely during the trial to the accused free of cost. Now, who can file an FIR? It can be the victim himself. It can be a witness who has seen the occurrence. It can be sometimes it can be the accused himself also who also files FIR, or it's sometimes the police officer of a concerned police station also files a FIR before the officer in charge. We must remember that all offences are against the state, and it is the duty of the state to prove the offences beyond reasonable doubt in order to secure a conviction under the Code of Criminal Procedure. FIR is a public document, so anyone who wants to look into the contents of the FIR, he can obtain a certified copy from the prosecuting inspector office, or in some cases, FIRs are even uploaded these days by the police in their website. If it is a case of offences relating to women, say for example outraging the modesty of a woman or the rape of a woman, in that case the FIR has to be recorded by a woman police officer who will exercise the power just like the officer in charge of the police station. Say for example, if an informant lodges an FIR and he dies before the trial is concluded, so what will be the consequences? If the death of the informant is in relation to the circumstances which the injuries were inflicted, or in relations to the facts of the offence which led to his death, then it can be used as an evidence under section 32 subsection 1 of the Indian Evidence Act, which relates to dying declaration, and it can be considered as a substantive offence. But normally FIR is not considered as a substantive offence. It is only to use for corroboration or contradiction or for the maker of the FIR. Suppose the FIR, the person who lost the victim who loses the FIR dies, then during trial the investigation officer cannot prove the contents of the FIR in terms of section 67 of the Indian Evidence Act, but so far the FIR is concerned, he can prove his signature in the FIR or the signature of the informant in the FIR, but the contents can't be relied. Why? Because to prove a previous statement as an evidence in the during trial, you have to read section 157 of the Indian Evidence Act, which provides for the procedure for corroboration of the witness's statement. Suppose there are serious omissions in the FIR, or there are statements which are made in the FIR, but during trial, when the prosecution witness or the informant deposed in the court, there is significant contradiction, then that contradiction has to be proved under Section 145 of the Indian Evidence Act. And how a contradiction has to be proved under Section 145 of the Evidence Act is that you have to bring to the notice of the prosecution witness or the informant the contents of the FIR or his previous statement recorded under 161, and that has to be again proved when the IO is summoned at the end of the trial, that these are the statements which were made by the informant to the investigating officer. So that will cover it in some other topic when we discuss the omissions or contradictions of the witnesses. Suppose in the FIR, the informant tries to exaggerate something in regard to the injuries sustained by the victim. Those can always be again contradicted by looking into the injury report, or if the person dies, then we can always look for those marks or injuries in the postmortem report. So it is not always advisable to exaggerate something which has not actually happened, and you make a mention of those things in the FIR may damage the prosecution case, or it may also be used to test the credibility of the witness under the Evidence Act. So, as a lawyer, first when we get a copy of the FIR, when it is for the purpose of bail or for the purpose of trial, we should first look into the original certified of the copy of the FIR. So, as a lawyer, first we have to look into the FIR and see who has signed the FIR. Suppose the FIR is written by the person not by the informant and by some other person, then we have to look for the note in the FIR, that whether there is a note in the FIR that this FIR has been written by someone else and the contents were read over to the informant. Suppose the signature is in English, the contents of the FIR is in Assamese, then or in English or Bengali or Hindi, and the informant doesn't know, then during cross-examination we can test whether that has been properly explained to the informant or not. Secondly, we have to see, when we cross-examine the informant or who is the prosecution witness during trial, we have to first see in his examination in chief whether there is a exaggeration, contradiction, embellishment or serious omission in regard to the statement made in the FIR, the 161 statement, and the statement that has been recorded during the trial during his examination in chief. If those things are carefully examined and it is brought out in the cross-examination of the witness, then it will, as a defense lawyer, it may help you in demolishing the case of the prosecution or the informant so far that particular witness is concerned. So to summarize, we should remember that FIR is the first information given to the police either in writing or in oral. If it is given in oral, it has to be reduced in writing. Second is that it has to be in regard to a cognizable offense. That means a police officer can arrest without warrant. Suppose a murder is committed and you take a warrant from the court, that at that time the witness may fled away and abscond. So in case of cognizable offense, the FIR is registered, and suppose the police officer doesn't register the FIR, you have to report it to the superintendent of police of the district or the commissioner of police. And FIR need not be an encyclopedia of all the things that has happened. It is only to initiate the criminal investigation. It can be used for the purpose of corroboration or contradicting the witness or the maker of the FIR, not for any other purpose. It is not a substantiated evidence. It is a public document. Only thing is that when the informant dies due to the circumstances or the facts of this case leading to his death and not to any other cause, then it can be used as a dying declaration under Section 32(1) of the Indian Evidence Act. So, and sometimes the admission in the FIR can also be used against the accused. But we should remember that when an accused files an FIR, we cannot compel him to give evidence against himself, which is a constitutional safeguard provided to an accused. But if the accused wants to give his evidence to prove or disprove the allegations against him, he can always give his evidence under section 315 of the CRPC. But for that, a request has to be given by the accused in writing, and an order has to be passed by the court. These are some of the concept we should remember in regard to the FIR from the practical point of view, or when you want to conduct a criminal trial in a case. With this, I conclude my discussion today, and hope that in future we will be discussing more other topic which will help the people in understanding the concept of law, or the junior advocates in conducting the criminal trial in the court. And I'll be waiting for your responses in my inbox. And if there are any doubt in regard to FIR, I'm always there to clarify you all.